Hello everyone, myself Prashant Tyagi, legal intern from team LEXIS and Company. I hope you all guys are safe and healthy. I hope you like my previous video. Please like, share, comment on my videos and subscribe our channel for getting latest updates. Today in this video, I am going to discuss the topic of registration of FIR is mandatory in cognizable offences. We will understand this topic with the help of famous case and a landmark judgment in the case Lalita Kumari versus Uttar Pradesh. It is a landmark case and a famous case that will help us to understand the registration of FIR is mandatory in cognizable offences. So let's start our video. At the very outset, I must record my utmost administration of the landmark judgment delivered by the Supreme Court of India in the case Lalita Kumari versus Government of Uttar Pradesh and others 2013, in which it has been categorically held that if a complainant approaches the police for registration of first information report, that is FIR, in a cognizable offence, it is mandatory for police to register the same. Most of the times it has been observed that the police tries to evade the register FIR on one pretext or the other, and it is the common man who has no push and pull who has to silently suffer everything. Officially, all higher ups, including the chief minister, are happy that there is a minimum crime in their state, which really is not the case, which is why I feel that this landmark judgment was urgently that I hope that it will send the right message and will make the police administration too serious in doing their job. The famous case Lalita Kumari versus Government of Uttar Pradesh and others 2013, Supreme Court in one very explicitly mentioned that while registering of FIR is mandatory and arrest of accused immediately on registering of FIR is not at all mandatory. Registration of FIR and arrest of accused person are two entirely different concepts under the law, and there are several safeguards available against accused person also has right to for anticipatory bail under provisions of section 438 of Code of Criminal Procedure if conditions mentioned there are unsatisfied. In appropriate cases, he can avoid arrest under the provision by obtaining an order from court. Arrest of person and registration of FIR are not directly or indirectly linked, and they are entirely different concepts operating under entirely different parameters. The para 83 of the Law Journal Supreme today of this very judgment mentioned above, where it is pointed out by Supreme Court that the object so ought to be achieved by registering the earliest information as FIR is inter alia twofold. One, that the criminal process is set into motion and it is well documented from the very start, and the second, that the earliest information received in relation to the commission of a cognizable offence is recorded so that there cannot be any embellishment etc. later. The 89 of this very judgment also lays emphasis on promote of registration FIR and enumerates the adverse fallouts of the delay in lodging FIR. The object of insisting upon promote lodging of report to the police in respect of commission of an offence is to obtain early information regarding the circumstances in which the crime was committed, the names of the actual culprits and the part played by them, as well as the names of eyewitnesses present in the scene of the occurrence. Delay in lodging the first information report quite often results in the embellishment, where is the creature of afterthought. Judgment also mention here what is contained in para 84 of this very landmark case in Law Journal Supreme today. Supreme Court says in this para that principles of democracy and liberty demand a regular and efficient check on police powers. One way of keeping check on authorities such powers is by documenting every action of theirs. Accordingly, under the Code of Criminal Procedure Code, actions of the police etc. are to be provided and written and documented. Now we discuss the obligation to register an FIR has inherent advantages. First, it is the first step to access the justice for a victim. Second, it upholds the rule of law in as such as the ordinary person brings forth the commission of cognizable crime in the knowledge of state. Third, it also facilitates swift investigation and sometimes even prevention of the crime. In the both cases, it only effectuates the regime of law. Fourth, it leads to less manipulation in criminal cases and lessens incidents of antedates of FIR or deliberately delayed FIR. The 5-judge Constitution bench comprising of Chief Justice P. Satavan Visavam, Justice B.S. Chauhan, Ranjana Prakash Desai, Ranjan Gogoi and S.A. Bobde was pronounced this landmark judgment stated categorically that we hold registering of FIR is mandatory and no preliminary inquiry is permissible in cognizable offences. The bench added that the police officials cannot avoid registering the FIR and action must be taken against them if no FIR is registered. Although the Criminal Procedure Code says that police must register FIR on receipt of complaint, generally it is the police which decides whether to formally register the complaint or not. A full stop must be put to his dangerous discretionary power of the police when it is more often than to misuse, and the latest landmark judgment is precisely the right step in the direction. A common man has to face more tension in registering FIR than he does when some offences is committed. The worst part is still his FIR is not registered, and our both government and the state and the central hardly do nothing to alleviate the hovering troubles faced by common men, and which is why the highest court in the India, the Supreme Court, had to give such a landmark judgment. It was held that if a discretion option of latitude is allowed to the police in the matter of registration of FIR, it can have serious consequences on the public order situation and can also adversely affect the rights of victims, including violating their fundamental right to equality. It is also clarified by the court that the arrest was not mandatory in all cases where FIR was registered. The Supreme Court further ruled that the upper pinnings of the compulsory registration of FIR is not only to ensure transparency in the criminal delivery justice but also to ensure judicial oversight. It is the first step to access to justice for a victim. Action must be taken against police officers who refuse to register FIR in such cases. Let me also divulge that the court also clarified that before registering FIR for cases involving matrimonial family disputes, commercial offences, medical negligences, causes or corruption cases, the police can conduct a preliminary inquiry. However, it should be completed within 7 days and it has to be declared that whether the case would be closed or FIR would be registered. The Supreme Court also made it clear that registration of FIR is mandatory and also that it has to be recorded in FIR book by giving a unique annual number to each FIR to enable strict tracking of each and every FIR registered by police officer as well as by competent court to which the copies of FIR required to be sent. I hope you like and understand this topic. Please like, share, comment on my video and subscribe our channel LEXCLIQ for getting latest updates. Thank you so much. Stay safe, stay tuned. Have a nice day.